a specialist legal advisor, fairly similar to a solicitor, but patent attorneys train in a different way. So, for example, patent attorneys usually have a background in some kind of science or engineering. I'm a physicist by background, and then the patent attorney trains on the job to become legally qualified so that they can advise their clients on all aspects of intellectual property law. I think there are about 1,700 UK patent attorneys, so it's relatively small in terms of all legal services. Well, it's an entirely separate legal qualification. It's got some of the same kinds of skills, some of the same kind of knowledge, but the training is very, very different. So you've got someone that's got the specialisation in some kind of scientific or technical area that gains the legal knowledge on the job, very much like an apprentice, as opposed to someone that's got a legal background that then perhaps moves into another commercial area. So it's just an entirely separate legal qualification. And the result is that you get someone that's got relevant legal knowledge, but is very, very specialised in the area of the law that they know about. So they've got a lot of in-depth knowledge about intellectual property law, particularly patent law, but they wouldn't know, for example, about conveyancing or the broad aspects of the law. I think if you're realistic about getting a job as a trainee patent attorney, you're going to need very high academic standards. There's a lot of competition in there, and you're going to need to have a good degree, so a first or a 2-1 from a good university. I think that's going to be the expectation. There are people that I know that are very successful patent attorneys with a 2-2, but you've got to demonstrate some other skills or something like that would make you really stand out against the crowd. And the problem is your CV might get rejected because there are enough people with good degrees that would be getting the interviews. The kind of subject matter has got to be science, engineering, something like that. And you've got to have some kind of technical degree. There are 2 qualifications for patent attorneys. There is the registered patent attorney in the UK, and there is the European patent attorney, which is essentially a qualification so you can represent clients before the European Patent Office. And there are 2 sets of exams for both of those qualifications. So you've got your UK exams that people typically take first, and then you've got your European exams. 4 papers in each. Each of the papers lasts, I think they last now up to 5 hours, some of the papers. They can be very long exams. The pass rates are quite low. So you're seeing maybe 40% pass rates, but in some exams, the year that I passed, one of the exams had a 16% pass rate. So only 16% of people got through. Often you find quite intelligent people who have done really well in exams that then find that these are the first exams that they've ever failed or had difficulty to pass. So there are lots of repeats. Well, in private practice, if you start as a new graduate, so you might be fresh out of university, you may have done a PhD, a relevant kind of PhD, and then you would start probably training on the job, literally working under a qualified patent attorney, assisting them. New graduates are quite useful because they've got a good understanding of current technology, so they can read through lots of documentation. There's a lot of reading in being a patent attorney, so they can read through all the technological information and provide a good summary to the person that's supervising them. And that's an immediately useful skill. There are some courses that people will go on in the early stages of their training. So some of those courses are done on a kind of day release basis, so 1 day a week. Some of those courses are done on a full-time basis for 3 months, and that will get you through the first set of exams. You can take a first set of exams purely being trained on the job, but most people don't do that. Most people go on one of the courses, for example, the Queen Mary course or Manchester University course, to get this first level of qualification. Then after that, you're doing more work, gaining experience. You're talking about maybe 4 years of experience or something like that before you go in to take your final exams. Once you're qualified, well, the world's your oyster, in the sense that you would then probably be an associate in a firm, so a qualified patent attorney, but not yet a partner. And then career path, don't know, anything between maybe 4 years to maybe even 10 years, people would generally aim to be a partner within a firm. Most firms are partnerships, so equity partnerships, so you would then be a business owner. And then, well, what goes after that? Retirement, I suppose. There are some patent attorneys that work for industrial departments, so they work for a particular company and they file patent applications for that company and advise the business on intellectual property issues. So pharmaceutical companies, for example, tend to have large patent departments of patent attorneys they employ who are providing their business units with advice. Yeah, yes, certainly. The European Patent Office is in Munich. I spent 3.5 years working in Munich, and there are a number of firms that are in more than one country. And I guess there will be opportunities to go and work in the US for sure. I think there are probably opportunities to go and work in China and the Far East. So without doubt, there can be an international aspect to it. Although I would probably expect that to happen later in your career, perhaps post qualification, rather than during training. Patent attorneys are often characterised as a strange bunch because you've got this combination of the technical interest. You've got to enjoy finding out about the technology. You need to have a good command of language to be able to write very specific legal wording, so that people so that you can write accurate patents. So it tends to appeal to people that are actually quite pernickety, people that are quite pedantic. You've got to have a good eye for detail because a single word could make all the difference to the value of a patent. But you've also got that issue that you have to be able to see the big picture of things. You've got to understand where in all of this technical information there might be an invention in there. So really it's people with a good command of language, people with an interest and good skills in science or engineering, and people, I think, with an eye for detail as well.